Good afternoon, ladies and gentlemen. Namaste, namaskar. I hope you had the good lunch break. Okay, let us begin because it is time. My name is Taeko Suzuki, attorney at law from Nishimura Nasahi, Japan. I'm very honored to be emceeing today in this afternoon. Next, session 3 is on party autonomy in nominating arbitrators and conflicts. I would now like to introduce or distinguish moderators and the speakers. As moderators, Mr. Amit Kapur, Senior Partner of J. Saga Associates, Delhi, and Mr. David Rivkin, MCIA Council Member, Co-Chair, Debevoise International Dispute Resolution Group, former President of the IBA. As speakers, Mr. Amarjit Singh Chandiok, Senior Advocate, Ms. Sarah Jayne Rufus, Associate General Counsel of Indigo, Mr. Richard Menard, Senior Foreign Attorney from Kim and Chang, Korea, Ms. Sampada Narang, the General Manager, Legal, ADM, Agro Industries, and lastly, Mr. Vivek Kapur, Senior Associate of Stephenson, Harwood. I'm handing the mic over to the moderators, please.
Thank you very much for the introductions, and thank you for coming back after lunch. We will try to make it worth your while for the next hour and try to prevent the post-meal nap that inevitably might want to occur by trying to keep this lively and interesting. We have 5 speakers. We have 5 different topics. We will ask each one of them to talk about one of them for just about 4 or 5 minutes to introduce it. We'll then have a little discussion among the panelists about that question. And then after we've done 3 of those, we will take a break for some questions and answers from the floor. And then we'll continue with the last 2 and then hopefully have some time again for questions and answers from the floor. So we want it to be lively and participatory, and we look forward to your thoughts as well. So simply, as you know, the topic is focused on party autonomy and appointment of arbitrators, which comes up in a number of different frameworks, particularly when we are thinking about institutional arbitration, the role that institutions can play in it, and I think one important point is that the institutional role really doesn't limit party autonomy, but it can help make the case proceed much more smoothly. But the MCIA has its own rules about it, which we will talk about for sure. But let me simply begin by turning the microphone over to our first speaker, Richard Menard, who is going to talk about the appointment of arbitrators by institutions. Richard.
Thanks, David. Is it on? Yeah, it's on. It's on, okay. I am very conscious that we have all just had a very good and very large lunch, and I am timing myself, and I have witnesses. And I ask you only to pay attention for 5 minutes, and then you can take your naps. So, of course, there are many circumstances in which an arbitral institution may appoint an arbitrator. I want to focus on the not infrequent situation where the parties or the party-appointed arbitrators, as the case may be, are unable to agree on a sole arbitrator or a presiding arbitrator, and the administering institution makes the appointment pursuant to its arbitration rules. Now, David rightly pointed out in his remarks this morning that the institution in that situation plays the important role of guiding and advising the parties in the selection of the arbitrator, the sole or presiding arbitrator, as the case may be, which is true, and that's a very important role that the institutions do play and should play. But I think it's important to remember that it's a two-way street, or at least in my view, it should be a two-way street. And so the question I'd like to put is, in this circumstance, which again is not infrequent, to what degree should the institution actively invite and give effect to the preference of the parties to the extent practicable. Now, obviously, the parties' preferences in this situation will not be entirely aligned. That's why the institution is stepping in, presumably. But there may well be certain characteristics of the presiding arbitrator or background or skill sets, maybe language skills, whatever it may be, depending on the particulars of the case, on which the parties can agree. And that can importantly narrow the field, and these sorts of characteristics or background or skill sets can be identified by the parties in collaboration with the institution. And I think that's not often enough done in that way, and I think it ought to be, is what I would suggest. I mean, sometimes the appointing institution will solicit such information from the parties, and of course, if such information is volunteered by the parties on an agreed basis, then one presumes that the institution will give effect to it to the extent they can do so. But I would suggest that this should not be ad hoc and adventitious as I think it is in practice. It should be the norm. An administering institution that's tasked with appointing a sole or presiding arbitrator should always, at least as a default position, seek the views and preferences of the parties and endeavor to give them effect to the extent practicable. Now, this can be as simple and straightforward as simply asking the parties what sort of background or traits they would like the arbitrator to have, and again, they may find there may be some ground of agreement which can help to guide the process. In all likelihood, there won't be full agreement, and it won't be possible to satisfy everybody completely, at least, but there might be enough common ground, as I said, to narrow the field and to increase the likelihood that the right or a more right arbitrator for the case and for the parties, for the circumstances will be selected. I mean, another approach beyond the sort of simple matter of a colloquy between the institution and the parties would be to invite the parties to submit a list of names, maybe an agreed list or some sort of if they can't agree, then perhaps a list consisting of names put forward by both parties that are arranged in alphabetical order or in a random order, so it's not clear on the face of it which party put forward which name. I mean, that could be perhaps paired with some sort of an opportunity for each party to strike one or two names from the list to decrease the chance of sort of an extremely bad selection from the viewpoint of one party. Now, none of these, I mean, you can imagine other approaches depending on, again, as David also noted this morning, the flexibility is an important aspect of the process, and much depends on the particulars of the case and the particulars of the parties. But you know, the fact that one party may end up more satisfied than the other party at the end of the process, that's likely to happen in any event if the arbitration institution makes the appointment without such consultation and without such invitation of views. So the important point that I would like to put forward and invite comments on is that the institution, as we all recognize, at least in the abstract, derives its function and its responsibility in this circumstance in respect of that case from the terms of a private agreement between contracting parties, and it should discharge its responsibility accordingly in that spirit, that is, in a spirit of transparency and cooperation as between the institution and the parties. So the name, that's to say the names of the arbitrator, the name of the arbitrator that's selected by the institution shouldn't be handed down as from Olympus, which I think often, perhaps unintentionally, is the way it sort of shakes out in too many cases. And I would just suggest that as a matter of best practice and as a matter of principle, there ought to be greater cooperation between the institution and the parties activated by the institution affirmatively.
Richard, thank you for that introduction, and you raise a very important point. And certainly we've seen differences in the way institutions handle this. Some are much more collaborative, others do kind of hand down an appointment from Olympus, as you put it. And so I'd like to ask the panelists, to what extent do you consider how institutions make that appointment and how collaborative they are in the process when you're selecting a set of rules to put into an arbitration agreement.
First you are the co-chair. Go ahead, go ahead. I can't supersede you.
No, sir, Mr. Shredder, please.
No, go ahead, please go ahead.
Go ahead.
I think one of the biggest challenges that you will always find, and this has been something which we've experienced in India, when there are public procurement contracts and state-owned enterprises, the instinct of going back to your own former employees or people who've been in the public sphere has been the instinct of fallback. Good news is the dust has settled on that. And a judgment by Justice Sikri, who spoke with us this morning, in the DMRC case where a foreign company which was supplying steel for the rails had to deal with an arbitration situation where the clause said that DMRC would recommend a panel of 5 out of which you had to select the arbitrator. Supreme Court eventually struck it down, saying that you select your panel of 31 and the party will choose, you can't recommend any 5. And the bottom line was that the challenge was these were all former engineers and employees of the corporation or public sector enterprises. Now that was one insight that has come through, and there's been the last on that, I think. The challenge of appointment will always go unless we get institutions going, and we still lack that. So I hope that, happy birthday by the way to MCIA, this goes ahead and we get institutions moving in that direction, and the state-owned enterprises accept institutions as the mechanism going forward.
No, but the fact remains is Justice Sikri in that judgment still recognized that it's not that every employee of the corporation will get disqualified.
Yes.
So you have to still consider that aspect, because he's notwithstanding that they struck down that position, they still upheld that position, that every employee or every engineer or everybody who was connected with the DMRC would not get disqualified. Therefore, even if the institution has to appoint an arbitrator in terms of the arbitration clause, it will have to take that into stride. And that's what Richard has probably said, that your consultative process has to start. And only when you, out of the given 5 names DMRC had given, if supposing the other side doesn't agree and there's an institutional arbitration, then the institution will have to do that consultative process. That's the end of the result. The purpose is only one. Purpose is neutrality, impartiality, and the person is good enough to do the just part. That's all.
Yeah, and thank you. And I think to me at least, I do pay attention to which institutions are more collaborative. And I'm sure the MCIA, as it develops more experience, is going to be very collaborative. But for example, the ICC is one where it kind of is a black box. Even when I'm an ICC party-appointed arbitrator, they don't really consult with us in terms of selecting which national committee they're going to use, and you don't have any direct contact with the national committee. But I think other institutions do have much more conversation with the parties, and I think what you need an institution for in the end is selecting an excellent arbitrator and then managing the case well. So to me, it's a critical issue in appointing, in determining which institution to use.
Yeah, I had a very recent experience with ICC in a pending arbitration that's currently pending, where they actually reached out to ask the parties their views about a particular range of characteristics in an arbitrator that was to be appointed, and the parties gave their views, and the parties' reviews were actually relatively aligned, and then the ICC went a different way.
Perhaps they're trying. They're working on it. It takes a little. It takes some time.
I guess they're walking the wrong way.
Yeah. So, some institutions, including the MCIA rules, provide that it's actually the appointment is finally to be made by the institution itself. And so, Sarah, if you could talk to everyone about the distinction between nominating and appointing arbitrators.
I'll actually just read my papers just because I'm conscious of time. But yeah, over the next few minutes, we'll briefly discuss the subject of nomination versus appointment of arbitrators, particularly in the context of autonomy of parties, and maybe just some practical thoughts for institutions to be a bridge in times of uncertainty, instability, and trouble. So typically in the case of institutional arbitration, there's a panel of experts from which parties can choose to nominate their arbitrators, and this allows parties to select an arbitrator possessing the necessary skill, experience, expertise, and legal acumen to quickly and effectively engage parties and discharge the dispute resolution process. Certain institutions prescribe a process for nomination of arbitrators by parties, followed by final appointment by the tribunal at its sole discretion, while others allow parties to nominate arbitrators from the panel of designated arbitrators. And however, should parties fail to agree, the tribunal appoints an arbitrator at its discretion. Finally, some institutions permit parties to nominate arbitrators and the third arbitrators to be appointed by the tribunal at its sole discretion. In ad hoc arbitration, parties are free to appoint an arbitrator. However, a case can be made that the likelihood of bias may often be greater in ad hoc arbitration as compared with institutional arbitration. We have safeguards in the Arbitration and Conciliation Act that curtail bias, partiality, or lack of independence, and these have been incorporated in the rules of arbitral institutions as well. And arbitrators are required to disclose any circumstances that give rise to any justifiable doubts as to their independence or impartiality. On the matter of party autonomy in institutional arbitration, where the final appointment of arbitrators is subject to the discretion of the arbitral institution, it may be worthwhile to spend a moment pondering the question whether the same is truly a paradox and whether the outcome could potentially be problematic. So where parties fail to present their nomination or the arbitrator is not appointed within the specified time frame, the institution steps in to appoint the arbitrator and the decision is final and binding. Needless to mention, the order may be challenged for setting aside the tribunal's order. Some arbitral institutions are empowered to override the parties' agreement on composition of the tribunal, regardless of the fact that an agreement between parties does in fact exist. When the express agreement concerning tribunal composition is so integral to the parties' agreement to arbitrate, such that the agreement to arbitrate would not subsist at all if that express choice were replaced by alternatives set out in the institutional rules. I suppose this really begs the question whether there is an agreement to arbitrate at all. A balanced approach to this paradox may well be that the express agreement between parties is subject to and consents to institutional discretion, and therefore there is no derogation from the principle of party autonomy. So we've seen a proliferation of arbitral institutions on an international and domestic level, but from the perspective of the aviation industry, where I come from, there is much ground to be covered in instilling faith in the minds of foreign manufacturers, vendors, lessors, and other service providers of the efficiency of institutional arbitration in India. So when nerves are frayed and parties look to institutions to be that bridge over troubled waters, one factor that may go a long way in instilling faith and confidence in the institution is having subject matter experts on the panel of arbitrators, and including those who understand well the nuances and the interplay of exchange control regulations, accounting requirements and practices, tax and customs laws.
Thank you, Sarah, very much for that comment. And of course, the MCIA is one of those institutions where even a party's agreement to appoint is deemed to be an agreement to nominate, so that the counsel makes the final appointment in the end. And that immediately begs the question, in what circumstances should an institution ever reject an appointment by a nomination by a party? And AS, you're going to discuss that. And then.
Thank you, Dr. No, I was only wondering that after the addition of 5th and 7th schedule in the Arbitration Act 1996, in fact, the autonomy of the party itself is now governed by those schedules, so they can't appoint arbitrator. It will be ineligible if it's contrary to Schedule 7, totally. So its own right has been curtailed, as Amit said a few minutes ago. The CCRA in that judgment had looked into that question and said, of course, everybody is not disqualified, but still, the subsequent decision of Justice Nariman says, if Schedule 7 gets attracted, ineligibility is absolute. So if that's absolute, then I wonder, somewhere somebody who is part of me in an organization would always be connected somewhere or the other. Maybe he has just signed the file, he may not have applied that mine. Whether an institution would be entitled to appoint that person, even if it's recommended by a party, is a question that the institution will have to take decision of in view of the law that is laid down. But I have something else to put a question to. We have seen today in our experience in the court, I think Niti mentioned in the morning in the opening remarks, that the Supreme Court has now sent a matter where the arbitration clause was different, but requested MIC to appoint an arbitrator. But supposing the court was to appoint an arbitrator, which is happening quite often, at least in Delhi, I find, the arbitral tribunal is appointed, but sent to Delhi High Court Arbitration Center, or maybe sent to Bombay, maybe sent to some other institution. And if the words used in the statute are that your impartiality must continue during the entire arbitral process, then who will get that right? Whether that institution will get a right, or will I come back to the court is a question I leave it for you to answer it. Because after all, if the arbitration is party autonomy, and that autonomy has already been withdrawn, in some way the court has already intervened in, and now sent it to an institution to do it. So the arbitration will be governed. It reminds me of a case of Videocon which said arbitration, the underlying contract is Indian law. The arbitration shall be governed by English law. The Kurial law shall be ancestral. The place of arbitration shall be Malaysia. So the question was which arbitration, which apply, whether Schedule 5, 7 would have any relevancy at all or not, are a question that will determine. So I was leaving that for you to answer. That supposing in a given case, the court appoints an arbitral tribunal, so exercise jurisdiction under 11, but sends it to the institution. Therefore, you are governed by the institution now, and supposing in between that something was to happen, who would appoint an arbitrator? I leave it for you to. And also consider this another aspect, and I think Amit was right in reminding me of it, that right from 1992, actually looking at it, we have already supplemented the Arbitration Act in another form, like the Indian Telegraph Act, SEBI, Electricity Act. In all these views, we have asked expert tribunals to look into the aspects. Of course, the party autonomy went away. That got diluted. But they are all expert that we are looking at it today. But in how many cases are we actually getting experts is another question I leave for the audience to answer that question. In which field, how many experts are we really getting into the arbitration? We are again, ultimately, our experience in India shows is either a retired Chief Justice, both of us, I and Amit, will appear on the other side and say, I have no difficulty in appointing Justice so-and-so, so-and-so, so. I think that culture needs to be changed, and I need to bring professionals into the arbitral tribunals as arbitrators, because they will be able to handle the situation. If Nakul has to be appointed an arbitrator, and I'm sure he has the enough experience in hand to how to do an arbitration. And for that matter, if Amit has to tomorrow do something in telecommunication, though we have a TD site available, but supposing there was some cross-border situation, how will we do it? In fact, we have a matter pending today where the court is insisting that we should go to arbitration, where the law said Saudi Arabia. Jurisdiction will be Saudi Arabia alone. Now we are already trying to find out whether we can go to Dubai and do such something. But these are issues that are coming up. This country has diversity of problems. We have diversity of conditions. We can't be compared with anybody else. And I can assure you, we should be proud of the fact that where we have reached, the institutions have done well. We need to strengthen the institutions. The institution only has a discretion. The word used is discretion. Normally, therefore, the party autonomy should be taken care of. Richard has already pointed out that normally, with the parties make a recommendation, normally an institution must appoint that, unless it has reasons, because disclosure under Section 12, in any case, would be made by him. We know what the position is. If it's disqualified, then obviously party can't insist on that. Otherwise, normally speaking, by a consultative process or by nomination or the request of the parties, the institution should normally agree to it, unless, of course, it finds a disqualification being suffered, or the person says, I'm already holding 20 briefs, and therefore I have no time. I'm again mentioning Nakul only because he'll one of them disqualified in this regard. So therefore, I'm saying, therefore, the institution will have to harmonize itself with respect to these two schedules have given us a way. The IBA has already now become the statutory recognized right in this country. And consequently, I can't violate the statute. No arbitrator, no institution can arbitrate it. Therefore, the institution earlier had a discretion, and I think even their discretion is curtailed by Schedule 7 today. Thank you.
Thank you. We will talk about the IBA guidelines a little bit later, but thank you very much for that. I do think that the right of the institution to choose, at least to leave to itself the final appointment process, is really a way to, in effect, protect the parties from themselves. In most instances, the institutions that have this right do go ahead and appoint the nominated arbitrators. But there are times when the institution may know from its own experience that a particular arbitrator has failed to meet his or her responsibilities in other cases, or the institution may be able to have a conversation with the nominated arbitrator about having, as you said, too many briefs or other issues that may get in the way of properly serving in a way that perhaps a party is unwilling to question the nominated arbitrator. And so this right of the institution, which the MCIA has in its rules, I think is a very important right to provide an extra layer of protection for parties. And I guess I'd ask our two users here if that right is important to them. Is it right to choose? The fact that you have the institution looking out, having the institution being able to back up, and even if and say to you, you may want to nominate so and so, but we happen to know for reasons from our own experience, so and so would not be a good arbitrator in this case.
Well, I do think that institutions would bring to the table the right candidates, maybe, with their expertise, experience and all. But as a party, and if I'm an Indian company, I would somewhere want to have my right to appoint an arbitrator because I think there is a trust deficit that we suffer from in India. So I would like to retain that right and say that out of the panel that the institutions have, I should be having the choice to appoint my arbitrator.
Right. Before we turn to the next two topics, as I said, now would be a time for questions from the floor about what we've discussed so far. Any questions? Yes. Hold on, here comes a microphone.
I'm Kapur Mittal from the Indian Navy. This regarding the...
Can you hold the microphone a little closer, please?
Yeah.
Thank you.
I want to know what is the hold on the arbitrator of the institute once an institution offers the arbitrator for appointment in ad hoc arbitration. That means in an ad hoc arbitration, when it has been agreed between the arbitrators and the parties, the fees which will be applicable, and it is agreed that, okay, the fees will be as prescribed by the institute. Now, somewhere down the line, the arbitrator changes his stand and says, no, this fees is not sufficient, I want double the amount. Now, what hold or control does the institute organize, and what remedy the party has at that stage with respect to the institute? Court remedy is separate. I'm talking with respect to the institute.
Amit?
Sir?
Well, I think he'll have to go to court. I don't think institute can withdraw that right. But certainly institute has something else to do. He will not no longer be on the pool of arbitrators of the institute for the next arbitration. That's the clear position. And that's, I think, what Richard just now said, that if the institute already has evidence with respect to the briefs being with me already 5 arbitrations, obviously he's not going to give me the 6th one. So it's the same way. So if this is the conduct of an arbitrator or a nominee arbitrator appointed by the institute, at least he's lost everything else then. If he's taking this double fee for no further, he wants to retire, then it's a different matter. But of course, revocation, I have my doubts. I don't think revocation will only be by the court. I don't think it will be able to.
So I'll just supplement. There is multi-layered protection.
Yeah.
Institutions have a schedule of fee. You can't just run amok and say, I want to charge more. Your question was an institution appoints an arbitrator in an ad hoc arbitration. No, that's an oxymoron. Either it's an institutional arbitration or ad hoc arbitration. You won't have an institution appointing for ad hoc. So let's stay with one or the other. So long as it's ad hoc, you'll have to go to court. If it's institutionalized, then their rules will govern. And there is a schedule in the Arbitration Act, which also gives you the fee. This is not a rapacious world where people can keep charging whatever they feel like. There's some accountability there. So I don't think that needs to be worried.
Question.
It's not an oxymoron, it's a fact, it's a real life situation I'm talking about. It's an ad hoc arbitration and not
Converted
1-2
into
cases.
Ad hoc arbitration converted into an institutional arbitration.
Yeah.
I mean, that's the question.
Yes, ad hoc arbitration, but the appointment of the arbitrator through an institute, and you're paying the institute for that appointment.
So then the other protections are there. The Arbitration Act schedule, is available and the court is available.
In this, unfortunately, in these circumstances, that is not applicable because this is before that. Yes.
Okay.
Go to
Next,
court.
I saw, we need another microphone. Microphone.
You're pointing out something which is very off happening in the Delhi High Court, and that is that where the arbitrator is appointed by the court and they send it to the institution. I think the idea is that the arbitrator will not be able to fix his fees then. Then it will be the institution fees. Because you see, what we are facing in India is, although the schedule of fees is there now in the Arbitration Act, but it is not being followed. It is really not being followed anywhere, and because the simple thing is because it doesn't match up. It doesn't match up. So that difficulty is there, but there is another aspect to it. I think the courts are still trying to dominate, if I may say so, the Delhi International Arbitration. I mean, it's an institution, and I think they should just leave it alone. Let it progress and let it do its own job. But appointing an arbitrator and then sending it to the institution, I don't think that really works.
Yeah. Sorry, Nish, and then, yes, and then Vivek.
Sorry, with your permission, can I just weigh in on this and perhaps just clarify one thing? The distinction is between institutional arbitration and ad hoc arbitration, okay? So we understand the distinction between the two. In institutional arbitrations, the institution administers the arbitration itself, okay? At which point in time, the fees of the arbitrator, how the arbitration is to be conducted, etc., is taken care of by the institution from an oversight perspective. I think the situation that the gentleman there is referring to is a scenario where an institution is not asked to administer an arbitration, but is asked to act as an appointing authority, merely appointing the arbitrator and doing no more than that. So effectively what the court is doing in appointing an arbitrator, that role is being given to the institution to do. Thereafter, once the arbitrator is appointed, it operates in exactly the same way as any other ad hoc arbitration that you have chosen to enter into proceeds, meaning warts and all. If the arbitrator decides to increase his fees, that's what you signed up to, because that's the feature of an ad hoc arbitration. So I think it's quite important to draw that distinction and not confuse the two.
Vivek.
I had a quick question for our two users. I think Sarah raised a very interesting question of subject matter experts, and then Sampada talked about the trust deficit. So my question to both of you is, in an Indian context, let's say you have an arbitration and you appoint, it happens a lot of times, you appoint a generalist, and you think you trust him, you might have used him, he might have been a judge you've seen, and the institution turns around and tells you that I think he's not the right choice. What would be your general reaction to that?
Well, it has to be supported with valid reasons, and there has to be reasoning, there has to be logic to it. I would say that I would give due respect to the institution's logic and reasoning, but there has to be some reason for that disqualification.
No, I meant not a disqualification. It's just a sort of pushback in a collaborative manner. They say, look, you need a subject matter expert. This is a big infrastructure dispute.
Yeah. So, from a personal experience, I can tell you. While I was working in the power sector, I had a very technical issue. Okay, a little subject matter issue, and I wanted to appoint the retired tribunal judge, who was a technical member with an appellate tribunal for electricity. The opposite side appointed a retired judge of the Supreme Court. And my MD looked at me and said that, no, you cannot appoint a technical expert in this particular matter because you have to match up to the standard that the other party is bringing to the table. So I think not just by the subject matter expertise that we look at it, at least in Indian context, whatever that limited exposure I've had, I think we also get swayed by many other factors. And I think the conceptually we think that you could assist an arbitrator by bringing in an expert, subject matter expert as a witness maybe, but not necessarily that the arbitrator should be a subject matter expert. But having said that, I think the institution arbitrations would kind of bring to table better candidates, maybe, and you could change the mindset and look at people who are experts and look at a cost-effective arbitration and a timely, arbitration that you could finish in a time-bound manner.
Maybe just to supplement what Sampada just said, I think especially from the industry, from an industry perspective, there's this huge interplay between exchange control regulations, tax, customs, accounting principles, and just a more finer appreciation of exactly what the interplay of all of these is, and how it impacts the decision-making process. That is something, and I think especially from the foreign counterparty perspective, they would really like to see that. And it would go a long way in instilling faith in the mind of a foreign counterparty when they go to arbitration, is that the person who is really looking at this is really somebody who's quite seasoned.
So my own experience with the LCIA, for example, I was on the LCIA court for a number of years, and the LCIA has the same right to determine whether or not to appoint an arbitrator who's been nominated, is that it is collaborative. They won't just immediately reject an appointment if they have some concern, but they will go back to the party and say, are you sure? And they may even explain why they have some concern, although their concern may be confidential, they may not be able to.
Well, that makes all the difference, right? I mean,
right.
Reasoning, and if it's genuinely consultative, I would think from the user's perspective, that makes all the difference.
Yes.
For mine, it does.
I think in the end, it is rare for them not to appoint. They may, if the party still goes ahead, they may say, are you really sure? And in certain cases, if they are worried about it. The other thing you do find is sometimes institutions will have a lower threshold about what's perceived as a conflict. If one side raises a conflict issue or challenge to something that's been disclosed, then it's up to the institution. But we'll talk about that a little bit later. So I think we'll save some time for Q&A more at the end, but let's move on to the last two topics. And Sampada, you were going to talk about the appointment of arbitrators procedures under the proposed Arbitration Conciliation Act.
Yeah, thank you, David. And I've learned that you already spoke about appointment of arbitrators in the morning today. So I'm going to keep this real brief. When I started my profession, we were under the 1996 Act, and I knew for a fact that, I'd learned that Section 11 petition is a good money spinner, and it could keep you busy for quite some time. When I changed hat and went in-house, and with a new proposed amendment, it was nice to see that you could straight away go for a domestic arbitration to the High Court, and the appointment would be much more simpler. You could get an appointment within 60 days period. At least there would be an endeavor to do that. You could be, the onus of proving or making a disclosure that they would be, there's no, they are independent, or there are no reasonable grounds to believe that they are partial, would be on the arbitrator. So you would have identified grounds for challenge. So those were the welcome change. However, there were the powers of the courts were confined to only looking at the fact whether there exists an arbitration agreement, and you could not have challenged the decision of the courts in an appeal. So in all, it was a good, change or an amendment that came into picture, and as a general counsel, it made much more sense to get some discipline even in arbitration. Now with the proposed 2018 bill, there's a lot of strength given to the institutional arbitration, and that's again, personally, I think it's a welcome change, because I personally believe that you would require subject matter experts in a particular sector to deal with an arbitration. Like, for example, right now I'm working with an agri-sector commodities company, and the ball game is quite different than what it was in the power sector. So I think it makes more sense to have people who have the knowledge and who understands the sector and also the rules, regulations that are concerning to that particular sector. So this is the graph that has, been so far in the amendment that has been brought into India. And my only question is, and I would take this opportunity to put this question to Mr. Chandiok and to Mr. Kapoor, whom I've heard extensively as a junior lawyer in Delhi High Court. So the new proposed bill in 2018 does away with the section 611, 6A and 7, which effectively means that the power of the court to look at the arbitration, it's not just confined to the arbitration agreement, but they have some discretionary power now, and you could also appeal against the decision. So how do you see this change? Like we had introduced something and now we are again going back to the old procedure. So what do you see is going to unfold? And
we'll have to actually watch how the act comes into play, but if the entire statute says every arbitration will have to be appointment through an institution, then I have, for example, 5 in Delhi. Now, who will appoint will be a question. The statute will have to dictate that also to us. Now, where should I go? So all those questions will still arise for us. But in any case, if the court's power can never be taken away, to my mind, court's power can never be given to an institution. It's given by statute, but court will still not lose its power to appoint an arbitrator. Now look at 14. 14 itself says if you remove an arbitrator, you can appoint another one. So where is that power gone? The power will not go to the institute then. It will go to the court only, which is terminating his power as an arbitrator. So all those questions will come in, but I think the Rajya Sabha is already debating on this issue as to whether we should first recognize the institutes before we make this amendment. That's exactly the point, I think, if my memory is correctly stating me, Mr. Chithambaram raised that issue, that should you first recognize those institutions somewhere before you make that as a statutory provision and before you deprive the court of that.
so would you like to...
So I agree. I mean, this is still in the making, so we need to see how it evolves. I agree with Mr. Chandiok. I don't think we can today foresee how it goes. The basic question which always will be for the legislature to see is how far do they legislate and whether they should legislate onto the party autonomy. Because ultimately, what's the fundamental of arbitration? And if it's taken away completely, other than in exigencies which warrant interference, then does it actually remain what it's meant to be? Yeah. So let's not try and completely destroy the substratum. And that will be the debate in the parliament. Let's hope that we'll get somewhere there. May I now invite Vivek to speak on the last topic, that is on the IBA guidelines on conflict and their relevance to India.
Right, thanks, Amit. I noticed I'm getting credit for some of the sensible things you said, so I think I can, say some nonsensical things. I think the IBA guidelines on the conflicts of interest have become very important in the overall context of appointment and challenge of arbitrators in India. And it's not only because the IBA guidelines is a very well-curated instrument that embodies international best practices, but because after the sort of first generation reforms in 2015, the Arbitration Act now requires mandatory declarations from prospective candidates of any circumstances which are likely to give rise to justifiable doubts as to independence and impartiality. And you will notice that this is the same standard as the IBA guidelines, the justifiable doubt. And the Act sort of goes one step further. Schedule 5 provides for various sort of presumptive grounds which would provide guidance on disclosure and by the same token on challenge of arbitrators, which are essentially drawn from the IBA list. It's, I understand it's the red and orange list, but it also has stuff like green list. Now, what is very different here is that unlike the IBA guidelines, Schedule 5, these things are not color-coded. You have 134 grounds, which are a mix and match of everything. And if you one sort of caught my attention, if you look at item number 33 on the list, it says the arbitrator holds a position in an arbitration institution with appointing authority over the dispute. Now, under the IBA guidelines, that's the green list, which is a very minor conflict, but it's essentially on this sort of same footing under Schedule 5 with item number 1, which is the arbitrator is an employee, consultant, advisor, or any of the past business relationships, has any past or present business relationships. Now, this is going to become very important here because this is ultimately going to be the basis of the challenge. And when the courts and the institutions start examining these challenges, they will have to look at the IBA guidelines and the sort of jurisprudence that is developed around it. And interestingly, in August last year, there was a case, HRD Corporation versus Gale India, and the Supreme Court was ruling on a challenge of appointment of a party-nominated arbitrator, and because he was involved in appointing the chair as well. And the Supreme Court held that since Schedules 5 and 7 owe their origin to the IBA guidelines, they should be construed considering the general principles of the IBA guidelines. So the courts and institutions are going to be extensively looking at that, and I think they're going to be very important in the Indian context.
Any thoughts? How do you see it?
Well, I think it's, I'm glad to hear of this development. I think the IBA guidelines were developed by our committee because they really filled a void. There was such disparity in the way that arbitrators made their disclosures. You would sometimes see an arbitrator not disclose the fact that he or she had been appointed by the same law firm 10 times in the last couple of years because the arbitrator was convinced that that did not impact his or her independence or impartiality. And you would see other arbitrators disclose that 15 years ago he had lunch with one of the counsel. And the institutions, while they were making decisions, weren't disclosing the standards that they were applying. Certainly from the IBA perspective, we've been very happy to see the guidelines take on the level of acceptance. They're not perfect, but they are a very useful reference point, and they have been, they are considered really by most institutions at least as guidance. But I think the other thing that the guidelines did, I should add, is put more emphasis on this issue. So you see more and more institutions now actually disclosing their conflicts determinations, so that parties and arbitrators can have an understanding of what they are actually doing, and that in the end is the best guidance.
So would you like to?
No, that's fine. I was only wondering, on one hand we want an arbitrator to make all those disclosures, on the other hand we are talking about arbitration is confidential. I don't know. How are you meeting these 2 points? I was only making that comment to you.
Shall we invite any questions?
I think there are 2 questions. They've been raising their hand.
Ganesh,
Hi. Ganesh Chandru from Delhi. This is just to add on to what Nish was clarifying to the gentleman's question about ad hoc arbitration, where an institution steps in. This is not uncommon, especially when you choose ancestral rules of arbitration to govern, to the arbitration. There's, of course, ancestral rules and ancestral model law are 2 different things. I think a lot of people get confused between the 2. Typically, in an arbitration where ancestral rules are kind of the rules that govern the arbitration, if the parties do not choose appointing authority, and then they can't agree on an arbitrator, then they have to go to the PCA at The Hague to appoint an appointing authority. And there are several institutions, at least a handful of them. One example is the SIAC in Singapore, where they do appoint arbitrators if the parties choose SIAC as an appointing authority for an ancestral case governed by the ancestral rules. They have appointment fees, which is very similar to what they would have done in an ad hoc arbitration in Singapore. But a very interesting thing which probably I thought I should share is SIAC also has this option of parties, even after the dispute arises, they could choose to have SIAC administer an ancestral arbitration. So it would have been an ad hoc otherwise. Then if you agree, either before or after the dispute has arisen, they have a separate set of practice notes for which SIAC would administer an ancestral arbitration. So that kind of situation can be avoided, which our friend said, where the fees is going to be exorbitant. Then once they agree, then they'll follow the schedule. Of course, then it becomes partly administered again, and they would do it as per the ancestral rules. For example, under Article 8 of the Ancestral Rules 2010, SIAC would follow the list procedure for appointment of arbitrators. So I just thought I'll add on to this.
The point is only one clarification that I need, that if the court was to say, refer the matter to MCIA to appoint an arbitrator, so would that not mean that and parties go there, the appointment actually takes place. So are we not actually by implication accepting that the rules of MCA would apply?
No,
There is the question of the only appointing authority being with them, and rest of the thing will still remain ad hoc. That seems to be a question that I at least would...
I think that's a very fair question, but what happens is the duty which it's given to MCA is just to appoint, and the parties will always say we didn't agree
No, but
to
it's
the
an order of
rules.
the court.
But if the court orders that
Yeah,
MCA
that's the
rules
point
has
I'm
to be
making.
followed, then
The court orders, and the example Niti gave this morning was
Yeah.
the Supreme Court sent the matter to Bombay to appoint. Now, if the Supreme Court has given the power of appointment to an institution,
yes.
I doubt very much that the remaining rules will not apply, only appointment will come. That I have my doubts.
No, if that happens, then MCA will be the happiest institution in India.
And especially if the arbitration has gone on after that.
I think Niti needs to work harder in convincing people that the rules must be adopted every time it comes from the court.
But it's clear, though, there is a difference between being an appointing authority and having the institution's rules apply, and that shouldn't be missed. And I would just, there are a number of other institutions that have rules by which they will administer an arbitration under the UNCITRAL rules, and that can be useful. But I would just add as a caveat, be very careful. You can do that with the UNCITRAL rules. I have seen clauses, and in fact, I've recently litigated a case where, for example, the ICC said arbitration pursuant to the ICC rules administered by the HKIAC. And the SIAC had a case like that, and the SEC had a case like that. It's gone to courts, and you can't mix and match institutional rules in that way. You can use UNCITRAL rules because they are ad hoc.
I'm Unmesh Shukla. I'm a lawyer practicing in Ahmedabad. In fact, whenever I go abroad, people ask me, where are you from? I have to say Ahmedabad, then say where. I say near Bombay. So we have always lived under the shadow of Bombay.
You should not say I come from the Prime Minister Modi's constituency.
Yes, we have at least one contribution in last 4 years. The difficulty with appointment power available with the institution is that there is a trust deficit on the part of the clients, and where I certainly agree with the madam who spoke about it. The question is that it is a very difficult and little unhealthy delegation of essentially a sovereign power of appointment, which is otherwise available under Section 11 with the High Court or the Supreme Court. So can we not have a kind of a compromise that such institutional power of appointment can be subject matter of some kind of a review or an appeal by the High Court? It may entail delay, but it's a kind of a compromise between two extremes, where institutions don't have the power at all, or they have an absolute unlimited power which can't be questioned.
I actually had an experience that I think is relevant to your question in Korea, in an arbitration in Korea not long ago, which is an ad hoc arbitration in which the court, the co-arbitrators were unable to agree a presiding arbitrator, and so the court was the appointing authority under the Korean Arbitration Act. And the court didn't delegate its power. It's not clear whether it would have had the power to do so under the statute, but it did seek input from the Korean Commercial Arbitration Board, and it solicited names, and the KCAB gave names, and it chose one of those names, and that's one sort of middle ground that I think could draw on the expertise of the institution without raising questions about delegation of sovereign authority.
Back.
Question on the back.
My name is Prithvi. I used to work with Three Crowns in London and recently relocated back to Delhi. So all of this is coming back to me now. But I wonder whether, at least in India, to what extent, because if we talk about party autonomy, there isn't really any point in having autonomy without information. And so I really wanted to get a view from the Indian panelists especially. How do you really judge whether an arbitrator is worth it? And to what extent can institutions actually have a feedback mechanism for the users to actually be able to understand whether the arbitrators they're going to appoint are actually going to deliver? So really bringing the question back to institutions in the long term, how can we have a sort of a feedback mechanism? And to what extent in India right now do we actually, by word of mouth or otherwise, how do we really appoint arbitrators today?
I think your question begs the first question, do we have enough institutions who have been here long enough appointing, monitoring, supervising, feedback? If you don't have the institutions, then obviously don't have the institutions to give you the information. It is as of now word of mouth, practitioners' experience, and the party's perception on it. One of the good reasons why we need institutions, because benchmarking of performance will come only when institutions supervise. They're dealing with arbitrators, 50, 100 of them, who are dealing with various matters. They have a feedback loop from the clients. They have ability to stand in and help, and then disseminate the information back to the arbitrators, so they understand what hurts the clients. Because ultimately, they are expecting inexpensive, quick, and reasonable decision making. They are not actually looking for the scientific decision, which will come 20 years down the line. And that is the big feedback loop which still needs to go back to many of the people who sit on the panel. And that will be important as we go along. But as of now, we don't have those institutions that have the feedback mechanism and the data.
I think we have time for one more question.
Good afternoon. My name is Mukund Chaudhary. I'm not a lawyer, so I won't be asking any technical questions. It's just a logic that I wanted to know. Institutions, and somebody touched upon disclosures by the arbitrators. So my question is, in forums like UNCITRAL and ICSID, normally most of the arbitration is between an investor and a state. And 99% of the times it is the investor who is the claimant. Now, if you look at the arbitrators that are appointed by the state, you will find that they come out of a list of arbitrators who have been appointed only by the state in 30 out of 30 arbitrations. So, which actually clearly shows that in the list of arbitrators, there are certain arbitrators who are clearly favored or are preferred by the state. So is that something of a technical nature by the institutions to be thinking about, that the states are preferring a particular set of arbitrators for all their arbitrations? And is it something that the arbitrator should also disclose?
So
obviously, the arbitrator will have to disclose if he has number of arbitrations referred to it. If 30 out of 30 are being referred to by the same state, PSU or the same...
It may not be the same state, but I'm just saying the state.
But therefore, if the person already is disqualified under the schedule, then he can't have more than one number of them. And in any case, if the institution comes in, institution will have his details with us. The only problem that I'm looking at is how we will be able to make these institutions come. Probably we'll have to also consider making a utility information agency under the Act now to see where all these data is considered.
There are also arbitrators who are only appointed by investors. And it is one of the issues in investor-state arbitration. There have been challenges to certain arbitrators because they have been appointed only by states, or they have too many arbitrations, and normally those challenges have not been accepted. But I think the other thing that you have to keep in mind, particularly if you're appointing, or even if not, is that an arbitrator who is always appointed by the same side may not have as much credibility with the ultimate chair. And so certainly when we're representing a party and we act for both investors and states, we don't look at the pool of people who are only appointed by one side or the other. With that, I think now we'll wrap it up. It's time for the next panel. Let me, on behalf of Amit and on behalf of all of you, thank our panelists for their excellent interventions, and thank all of you for your questions as well.
We thank the chair and the co-chair both.